My name's Todd Sivia, and I'm the owner of Sivia Law. Today we're going to be talking about planning for your golden years. So some common questions that we normally get is, how much is it going to cost? So our consultations usually run anywhere between $0 and $500. A typical plan can be as simple as a simple form, which may cost only $100, but it could range all the way up to $8,000. It just depends upon the complexity and the goals of our clients. Why is planning important? Planning is important, 1, to protect yourself, 2, protect your family, and 3, protect your assets. Things to consider. So there are so many things that we need to consider with regards to planning in your golden years. We've got issues with regards to your general estate plan. Power of attorneys and making healthcare decisions and financial decisions in case you become incapacitated. But we also need to be thinking about things like long-term care. So those include like Medicaid and long-term care insurance. Other things that we're going to be considering is, are you a veteran? Do you qualify for certain veteran benefits? And of course, we need to consider guardianships, whether we're going to need a guardianship in your case or not. Hopefully we don't if we do proper planning. Let's talk about general estate planning. So in a general estate planning, if we're looking at and evaluating your current estate plan, we need to ask the question, does it carry out all of your wishes? Things change over time, and our issues that we originally thought back when we were younger may not still apply, because we may be planning for not only our kids but also grandkids and sometimes even great-grandchildren. So we need to consider all your wishes with regards to those. Have you considered minimizing costs? Costs today and costs in the future. Our firm, we really focus in on probate prevention. So, trying to minimize the costs associated with probate and avoiding probate. So we look at minimizing those costs. But we may be also trying to minimize other costs for nursing home help or long-term care, things of that sort. So we're also looking to reduce time delays. In probate, there are certain time delays that we have to look at, including probate can take up to 2 years. So we're trying to avoid holding up an estate and distribution for a number of years. We're also trying to minimize tax liability. In the state of Illinois, the state tax is $4 million. So we're trying to reduce that. Now, not everybody, this doesn't apply to everyone, but there are some tax considerations with regards to doing things. Maintaining privacy. There's so much that is unsaid about maintaining privacy within an estate plan. If it's in your estate planning documents and you got to file it with the court, that court document now becomes public, and we want to try to avoid that. And we're trying to shepherd your assets over the long haul and provide some kind of management tools that you can instill in your estate plan. And these are all considerations that you need to be thinking about with regards to your estate plan. What documents could be included in your estate plan? Some of these documents include a simple, durable power of attorney, healthcare directives, maybe some prenuptial agreements or postnuptial agreements, definitely a will, certificate of trust, and then also funding your documents. And that's one thing within our organization that we do a lot of is actually fund a trust. and that's just as important as the documents themselves. So, you know, if you need help with just the funding part, please contact our office, and we'll see what we can do to assist you. So, power of attorneys. So, a power of attorney is a written authorization to represent or act upon another's behalf in people's private affairs, business or healthcare. So, unlike typical power of attorneys, durable power of attorney remains in effect even if the grantor becomes mentally incapacitated, and that's very important. You know, the question is, does your power of attorney authorize the grant of gifts? Do they have the power to access retirement benefits? Do they have access to sell real estate? Do they have the power to create trusts or to become Medicaid eligible? You know, there's a lot of things that you need to have authority for. One other thing is digital assets. You know, it's important to have your digital assets available. You know, everybody these days has Facebook. They have online bank accounts. They have online credit card accounts. And all that is all digital assets. And if your power of attorney does not authorize you to authorize your agent to be able to access those things, they really can't. And so in looking at your power of attorney, you want to make sure that you've actually looked at your power of attorney and make sure that your power of attorney has those provisions in there. Guardianship. So if you don't have a power of attorney, guardianship is the next level. Guardianship is a protector declared by a judge in order to protect and manage the financial affairs of an everyday person. Guardians get to oversee the estate. They can manage healthcare decisions, physical and mental disabilities, and dementia. So guardianship, really, it's there, but we really don't want that to happen. So if you have a power of attorney, then there's really no need for guardianship. Living trust. So living trust, if you want to shepherd your assets through and try to funnel your assets in order to avoid probate and things of that sort, a living trust may be an option for you. So living trust has 3 phases. Phase 1 is grantors have the management. Phase 2 is survivors or trustee has the management. Phase 3 has beneficiaries receive their property. So those are 3 very important steps. So, and it's important to note, the grantor is you. So the person that is in control is truly you that has control of all your assets. A trust can be funded by your real estate, bank accounts, stocks, bonds, mutual funds, gold, silver, and then have a plan for distribution. So using Mary Smith as a perfect example, if Mary passes away and she owns real estate and or assets over $100,000, she must go through the probate process. So if she passes away and does not have a living trust or revocable trust, then all of her assets must go through probate. Now, let's say Mary decides, you know what, I'm going to go ahead and get a trust and establish the trust. So then she becomes incapacitated or she passes away. Then Agnes steps in as trustee. Then or another successor steps in. Then it kind of funnels, all your assets funnel through this trust, and all these assets are then distributed to your beneficiaries. The important, one key point to this is when you have assets all over the place, and we're dumping these assets in this funnel, and if you ever want to make changes to that funnel, then you don't have to go through to all your bank accounts and real estate and try to figure out where everything is supposed to go. You make one change within your trust and it changes all the distributions. So our next slide talks about special needs. So if you or if you know of anybody that has special needs or has any kind of disability, or maybe drawing Social Security disability, or receiving any kind of government benefits, it may be important for you to think and consider having a special needs trust. And generally this protects the future well-being, usually education, healthcare, living arrangements to an individual with special needs. And protects any kind of gifts for the future, and protects the assets subject to creditor seizure. And that creditor seizure can be the government and or requiring some kind of spend down. So who qualifies? Typically special needs trusts or anybody that is disabled who under the age of 65. There are first party trusts where if somebody inherits money and we're trying to protect that money, we may put it into a first party trust. But those first party trusts require funds to be used on anything that Medicaid does not cover. Let's look at the facts. The average American spends approximately $8,300 to $8,400 per month on a nursing home. So the average stay at a nursing home is approximately 835 days, or about two to 2.5 years. That is a total of $230,000. So if that's a concern for you, where you may not have $230,000, or the assets that you own are illiquid, so thinking about land, thinking about assets, and you can't access that $230,000, then we need to set up a plan for you. So Medicaid planning. The reason why Medicaid planning is so important is, again, looking back at the average cost. If it's $70,000 to $80,000 a year, in-home health care is $120 to $150 per day, and your assisted living care costs are between $24,000 and $50,000 per year. Those are high costs, and we need to consider, when will your assets fall below to a point where it's $2,000, where all your assets combined are $2,000. That's where Medicaid kicks in, and that's why we need to do some planning. With Medicaid, there's an application process, and they're going to be looking at everything you've done from a banking transaction for the past 5 years. We actually have to provide them with copies of 5 years of your statements. So we want to try to protect your assets as early as possible to avoid dealing with any kind of spend down. Any client that mentions this presentation receives a free 30-minute consultation. When we talk about veterans is kind of a separate area, and anybody that served in our country, we really appreciate all the service you do and you did for our country. But veterans that served during wartime, there are benefits available to those veterans, and those include 3 classifications for what's called pensions. There's a basic pension, household, and aid and attendance. So if you're housebound and you need assistance, you may have the ability to receive assistance for your long-term care. Same thing with aid and attendance. If you need aid and attendance at a nursing home, there may be access to funds for those benefits. So Veterans Administration requires an honorable discharge. You had to serve at least 1 day during wartime, and 90 days of service. You must be living in an assisted living facility, paying for long-term care on your own, and then you receive some kind of cash payment on a monthly basis for your long-term care. So key areas and time periods. World War II started December the 7th, 1941, and it ended in 46. So on December the 31st, 1946. Korea is a little bit kind of the same way, where the technical time periods of war are not truly the time periods that VA actually looks at. So Korea is from June 27th, 1950 to December the 31st, 1955. Vietnam is kind of a two-part series, and kind of has a little bit of nuance to it. The true date of service was August the 5th, 1964 to May the 7th, 1975. But if you served in country, or if you went to over to Vietnam before or after February the 28th, 1961, then you may also qualify. Disability compensation is not limited by veterans' income or assets. Surviving spouses also receive this assistance. So if you're married to a World War II veteran and you needed some assistance, you also qualify as well. So wartime veterans, spouses may be eligible for up to $19 to $2,000, or wartime veterans, $19 to $2,000. Surviving spouses may be eligible for up to close to $1,100. Requirements include wartime service, you've got to have medical expenses, and then you truly need assistance. Benefits of trust. The benefits of trust is the trust takes effect during the grantor's lifetime. There's no court supervision, and it establishes how assets are dispersed due to any kind of death or incapacity, and also avoids probate. If you have any questions, please don't hesitate to reach out to us. Call. We have multiple locations to serve you, including a new office in South County and also in East Dalton. But our Edwardsville and our Brentwood locations are always here to serve you as well. Look forward to seeing you again. Thank you so much for listening to our webinar.